Intellectual Property Association of the Philippines President Attorney Maria Trinidad P. Villarreal and its members.
Member agencies of the National Committee on Intellectual Property Rights, namely Department of Justice, Department of the Interior and Local Government, Department of Trade and Industry, National Bureau of Investigation, Bureau of Customs, Philippine National Police, Optical Media Board, National Telecommunications Commission, National Book Development Board, Food and Drug Administration, Office of the Special Envoy on Transnational Crime, Licensing Executive Society Philippines,
Integrated Bar of the Philippines President Domingo Egon Q. Cayosa and its members.
Philippine Bar Association President Benjamin T. Bacoro and its members.
Philippine Association of Law Schools President Mirasol D. L. Anenias, Deans and Faculty Members.
Members of the Subcommittee for the Revision of the Rules of Procedure for Intellectual Property Rights Cases.
Members of the media, with special mention to the Justice and Court Reporters Association, or JUCRA, and Justice Reporters Organization, or JUROR.
The Judicial and Bar Council, members and lawyers.
Mandatory Continuing Legal Education Office, Governing Board members.
The Philippine Judicial Academy, officers, Corps of Professors, and members of the Academic Council.
Supreme Court officials and employees. Please rise for the ecumenical prayer, singing of the national anthem, and the Supreme Court hymn.
Almighty God, who stand in your holy presence as our supreme judge, we humbly beseech you to bless and inspire us, so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness, for the fulfillment of the Lord.
Good morning. Welcome to the media launch of the 2020 Revised Rules of Procedure for Intellectual Property Rights Cases.
I am Brian Keith F. Hosaka, Assistant Court Administrator and Chief of the Public Information Office. I will be one of your hosts for this event, and with me is
I am Laura Cruz Herrera del Rosario, Judicial Reform Program Administrator from the Supreme Court Program Management Office.
we are here today to inform the participants about the revisions that were introduced to the existing rules of procedure for intellectual property rights cases. The revisions are the product of extensive and thorough discussions by stakeholders from various sectors, including practitioners, the academe, the IPOPHL, and the judiciary, with the goal of improving, facilitating, and expediting cases in response to the ever changing landscape of IP rights litigation in the country. The 2020 IPR rules are designed to foster a legal atmosphere that ultimately spurs creative activity and innovation, technology transfer, and foreign investment.
Aka Brian, our distinguished speakers will discuss what exactly are the revisions to these rules. But before that, there will be an audio visual presentation on the revisions. In watching this, we become witnesses to the continuing commitment of the judiciary to work for the efficient delivery of justice.
And now, to formally welcome the participants, may we call on the Honorable Jose Maidas P. Marquez, Court Administrator, to read the welcome remarks on behalf of the Honorable Justice Alfredo Benjamin S. Caguiwa.
Uh, I was requested to read welcome remarks of the Honorable Justice Alfredo uh, Benjamin Caguiwa. To our distinguished guests, Secretary Ramon Lopez of the Department of Trade and Industry, Director General Roel S. Barba of the Intellectual Property Office of the Philippines, Attorney Maria Trinidad Villarreal, President of the Intellectual Property Association of the Philippines, Chief Justice Diosdado M. Peralta, and his wife, Court of Appeals Associate Justice Fernanda Lampas Peralta, the Associate Justices of the Supreme Court, the Presiding Justices and Associate Justices of the Appellate Courts, Justice Adolfo S. Tascuna, Chancellor of the Philippine Judicial Academy, members of the Intellectual Property Rights Subcommittee, good morning and welcome. On behalf of the Court and the Intellectual Property Rights Subcommittee, I would also like to extend a warm welcome to our guests who are with us via online live stream. To the special commercial court judges, members of the Philippine Judges Association, all IPR practitioners, and members of the IBP and the Philippine Bar Association, welcome, and we are all glad that you could join us. Today marks a key point not only in the history of the court's exercise of its rule-making powers, but more farsightedly in the shifting landscape of IP rights litigation in the country. After a comprehensive collaboration with the various stakeholders from across the field of intellectual property rights and under the auspices of the Peralta Court, through the very able leadership and inspiration of our Chief Justice, it is now both our pride and honor to officially introduce to you the 2020 Revised Rules of Procedure for Intellectual Property Rights Cases. These 2020 Revised Rules of Procedure have been crafted with the end in view of facilitating and expediting the resolution of IPR cases and ultimately creating a legal atmosphere that is most conducive to the energies of creativity and innovation. These rules aim to further untangle the procedures relevant to IPR cases so that creators and innovators may be free from unnecessary bureaucratic delays and cumbersome legal processes. Perhaps in the face of this long-standing public emergency, there may be no better time to encourage ingenuity, resourcefulness, and imagination than now. There may be no more crucial chance to enhance respect for intellectual property and evolve the rules alongside emerging issues in IPR adjudication than now. When we are as a people are hard pressed to think outside of boxes, push back against unforeseen restraints, and scaffold an economy that is reeling in this pandemic. There may be there may indeed be no better occasion to strengthen protection of intellectual property rights than today, when ideas and our creation thereof are vital in transcending our new limits. Our hope is that these revised rules can be an enabling mechanism that will only serve to improve the national platform for innovation and embolden the far-reaching promise of our nation's creative potential. Again, on behalf of the court, welcome everyone.
Thank you, Court Administrator Marquez, for reading the message from Justice Kadiwa. Court Administrator Marquez is also a member of the Committee on the Revision of the Rules of Court and of the Subcommittee for the Revision of the Rules of Procedure for Intellectual Property Rights cases.
Now, to provide an overview of the tedious process of revising the rules, let us watch an audio-visual presentation prepared by the Supreme Court Public Information Office.
Revised Rules of Procedure for Intellectual Property or IP rights cases has a long history that dates back to 2009. The effort was forged on the vision of creating an efficient justice system for our innovators, creators, and businesses. The 2011 rules have indeed given concrete form to this vision, making procedures more organized and convictions of IP violators easier to attain. However, fast forward to today, business and ecological landscapes have changed. New regulations and policy structures have been made, compelling the need for more modern rules of procedure that can capture new realities on the ground and therefore continue to effectively protect IP rights. In 2019, IPOphil, through the vision of former IPOphil Director General Josephine R. Santiago, pushed for these much needed revisions to the 2011 rules. The effort stemmed from IPOphil's consultations with various special commercial court judges, IP rights holders, and IP organizations to address some gaps and bring more clarity to procedures. Chief Justice Diosdado Peralta took immediate action by reconvening the subcommittee for the revision of the rules of procedure for intellectual property rights cases. Work on these revisions began in earnest and was sustained in the months ahead, notwithstanding the challenges brought about by the COVID-19 this year. And while 2020 has been hurling the country with a series of unfortunate events, the judiciary offered some positive news. In a significant move, the Supreme Court and Bank promulgated the 2020 revised rules of procedure for intellectual property rights cases. Among the rule's salient provisions include first, the reduction of the period for rendering judgment on regular cases to 60 days from 90 days. Also, it allowed additional special commercial courts to issue writs of search and seizure in civil and criminal actions. Specifically, special commercial courts in Baguio City, Iloilo City, Cebu City, Cagayan de Oro City, and Davao City shall now have authority to issue these writs. A list for the first time on what shall be accepted as proof of actual use of a mark in trademark infringement and unfair competition cases was included. It accepted market form survey as evidence to prove primary significance, distinctiveness, or status of a mark and or likelihood of confusion. And it also mandated the training of judges and court personnel by the Philippine Judicial Academy in coordination with the Office of the Court Administrator. Teleconferencing, video conferencing, and other electronic modes are now allowed in taking depositions. Also, the order of destruction was revised to include disposal of infringing goods, related objects, or devices, specifying the manner or method of disposal and or destruction thereof. Courts may also issue an order disposing of them by way of donation for humanitarian use, subject to conditions. However, those classified as hazardous shall only be subject to destruction. The revised rules strengthens further the Philippine IP system and paves the way for faster proceedings as relevant rules are harmonized. With updated rules, proceedings for IP cases will now be in sync with the updated rules and laws, such as the revised guidelines for continuous trial of criminal cases, amendments to the 1997 Rules of Procedure, new rules on evidence, and the Ease of Doing Business Act of 2018, to name a few. This improved coherence to the rules will help judges and litigators be more certain of how to go about the proceedings, hence clearing the way for any confusions that may cause judicial delays. In addition, the knowledge of the members of the judiciary on IP with regards to the latest trends, both local and international, will be enhanced, given the push to mandate continuous IP training for court judges and prosecutors. In all, the 2020 revised rules enables IP rights holders to have greater access to justice, in turn creating an environment that is conducive to innovation, creativity, and fair competition.
At this point, we would like to thank the Chief Justice and the Supreme Court Public Information Office, headed by my co host, for the production of the AVP, which will not only serve its purpose here during the media launch, but shall be used for further information dissemination.
We also acknowledge the invaluable contribution of the Intellectual Property Office of the Philippines, whom the Chief Justice requested to prepare the storyboard and script for the AVP.
Of course, we will acknowledge the members of the subcommittee for the revision of the rules of procedure for intellectual property rights cases. For Memorandum Order numbers 82 2019 and 11 2020. Chairperson, Chief Justice Diosdado M. Peralta. Vice Chairpersons, Justice Alfredo Benjamin S. Cagiwa. Justice Alexander G. Hesmundo. Members, Court Administrator Jose Maidas P. Marquez. Special Commercial Court Judge Ethel V. Mercado Gutay. Special Commercial Court Judge Elma M. Rafalio Lingan. Court of Tax Appeals Associate Justice Rowena Modesto San Pedro. Attorney Dorothy L. Peralta. Deputy Director General Nelson P. Laluces. Director Lolibeth R. Medrano. Attorney Ricardo R. Blancaflor. DTI Assistant Secretary Alan B. Hepty. Attorney Ramon S. Esguerra. Attorney Ferdinand M. Negre. Serving as consultant is retired Supreme Court Associate Justice Francis H. Hardelesa. And of course, the Secretariat, Attorney Jeffrey G. Gallardo, Attorney Antonio Cesar R. Manila, Attorney Camille Sue May L. Ting, Attorney Justin Adriel E. Ordoyo, and Attorney Maria Lisa L. Tolentino.
Now, To discuss the salient features of the revision of the rules of procedure for intellectual property rights cases, we are honored to present one of the vice chairpersons of the subcommittee on the revision of the rules of procedure for intellectual property rights cases, a member of the Committee on the Revision of Rules of Court, or the Mother Committee, and Associate Justice of the Supreme Court, the Honorable Alexander G. Esmundo.
Good morning, everyone. For expediency, allow me to, with leave, to adapt the salutation made by Court Midas Marquez on behalf of Justice Benjamin Kugiwa. Apparently, there's some overlapping because of the video presentation on by Director Laluces, because he discussed preliminarily the highlights of the revisions made in the rules on intellectual property. So pardon if I restate or repeat what he had said earlier. The revised rules on intellectual property cases took effect on November 16, 2019 upon approval by the Supreme Court and Bank. In revising the rules, the committee adopted, for purposes of uniformity or simplicity, the 2019 amendments to the revised rules of civil procedure, the 2019 amendments to the rule on evidence, the revised guidelines for continuous trial of criminal cases, the rule on cybercrime warrants, recent legislation, specifically amendments to RA 8293 or the Intellectual Property Code and jurisprudence. As pointed out earlier, the revisions were the result of consultations with various stakeholders as regards intellectual property cases. Let's go to the next slide, please. You will notice that for purposes of scope, the application of these revised rules on intellectual property, there were added provisions of law that will be covered by the rule, specifically repetition of infringement of patent under Section 84 and the layout of integrated circuit 119. This basically addresses the issues on intellectual property concerning technology. Likewise, added to the scope is the infringement of plant variety protection under Republic Act number 9168 or the Plant Variety Protection Act at Section 47. As pointed out earlier, under the revisions also, additional commercial courts in other urban cities were added to the list of courts that were originally confined to Metropolitan Manila area as having authority to issue search and seizure which are enforceable nationwide. The reason for this is proximity and immediacy. But it doesn't detract from the fact that the special commercial courts that are not enumerated but having jurisdiction over intellectual property cases continue to have authority to issue this search and seizure writs, provided that they are only enforceable within their respective territorial jurisdiction. Next slide, please. Commencement of action. The significant change in this rule on Rule 3 on commencement of action is with regard to prohibited pleadings and motions. Specifically, we adopted the provision in the amendments of the civil procedure while the motion to dismiss still a prohibited motion, but we allowed the four exceptions which are based on Rule 9, Section 1 of the Rules of Court. This was lifted from the provisions of the amendments in the 1997 rules. You will notice that these grounds appear or occur or recur in a number of the provisions in the 1997 in the amendments to the 1997 rules on civil procedure because they are essential for the easy or expeditious disposition of cases. We adopted also the specific limitations when a party may file a reply under the rules on civil actions in the intellectual property amended rules. A reply is allowed only if the answer is based on an actionable document. We also adopted the period of filing responsive pleadings. Only one motion per extension of time shall be allowed, totaling 60 period within which a party or a depending party in intellectual property cases to respond to a complaint. We also adopted the grounds for motion for postponement. The same rationale when we adopted it in the rules on civil procedure is to avoid delay in the disposition of cases by the postponement sought by litigants in court. Next slide, please. Rule 4 summons. We adopted also for purposes of the rules on intellectual property cases the rule on substituted service of summons because in the course of the discussion, intellectual property cases also faces hindrance, specifically on the service of summons to the defendant. So we adopted that provision where you will notice now that there are various ways by which substituted service can be effected. Again, I would like to emphasize we adopted technology by allowing sending of electronic mail to the defendant's electronic mail address if allowed by the court as a mode of service of summons. Take note that the service of substituted summons is not alternative. It is successive. The resort to electronic service is the extreme measure that can be adopted to effect that expeditious service of summons. Next slide, please. On summons and orders, we just amended it with respect to the what constitute doing business in the Philippines. We adopted that provision that doing business as defined in law. For example, in the Foreign Investment Act, what constitute doing business is specified in the law because legal issues have cropped up that reaches the Supreme Court what constitute doing business to acquire jurisdiction over the person of either plaintiff or a dependent in an action. We also adopted that provision on, next slide please, extraterritorial service of summons by as provided international conventions to which the Philippines is a party, it's also a member. Because we have to comply with our treaty obligations, one of which is with respect to extraterritorial service of summons. Again, this is intended to facilitate the service of summons where the defendants are outside of the Philippine jurisdiction. Next slide, please. Take note that we also adopted a provision in the rules of court on civil procedure as regards what is required when you file a pleading. We have now allowed and adopted in the intellectual property rules the requirement that when you file a pleading, whether it's asserting a claim, which means a complaint, or a responsive pleading, meaning an answer, parties are now required to include the evidence in support of their factual allegations. This is precisely to expedite the assessment of the case by the special commercial court judges, because the reality is that if a judge should immediately assess the complaint, he has the opportunity to dismiss it outright. Following the interpretation of the provision in the Rules on Civil Procedures amended, Rule 14, Section 1 says, unless dismissible under Section 1 of Rule 9, which are the grounds mentioned earlier that I told you was adopted, if any of those grounds exist in the complaint and the judge sees that these are present, the judge need not wait for the responsive pleading. Outrightly, he can have the complaint immediately dismissed. The responsive pleading is the same, 30 days, additional period of 30 days. Section 3 on Rule 5 deposition, we'd like to announce that the Supreme Court very recently, I think 2 sessions ago, approved the guidelines on video conferencing. And under the guidelines, video conferencing in lieu of in-person court appearance is now allowed in all actions and proceedings under the rules of court. So for purposes of cases involving intellectual property cases, video conferencing, such in situations of depositions, are now allowed. For purposes of Rule 6, which governs pretrial, upon suggestion of Chief Justice Peralta, we modified the sequence because ordinarily a pretrial comes after CAM or court annex mediation and then JAR, Judicial Alternative Dispute Resolution. The Chief Justice Peralta thought that, why don't we reverse the situation? Because if a judge is really good in conducting pretrial, CAM or JAR may not be necessary anymore. CAM and JAR would happen only if after pretrial there remains to be a controverted issue that needs to be resolved at least by way of CAM or JDR. Because in the old rule, these two process, JAR and CAM, comes ahead of a pretrial. And at the end of the day, based on experience, it causes a lot of delay also at the very stage of pretrial. Schedule of trial. Again, the issue that bugs the court is the speed by which cases are disposed of. And this holds true also with intellectual property cases. So what were the revisions introduced? We provided within what period the trial should commence. It should be within 60 calendar days after termination of pretrial or in certain instances where clarification hearings are need to be conducted. So now it's possible to have a timeline because every period now is fixed in the rules. Unlike before, certain discretions are allowed. Typically, for example, the period to file a responsive pleading or answer. Invariably, experience has shown that prior to the amendments of the rule, what happens is that the period to file answer comes in piecemeal requests, right? And the judge cannot keep track of the period of how many days extension have been granted. And at the end of the day, a total of 365 days have been exhausted. Now, with this amendment, the judge, as I've been saying in my lecture in amendments, the judge can input in his computer the specific dates when the answer becomes due because the original period is 30 days and one extension of 30 days totaling 60 days. And if you put that in your computer, the expiration period will simply pop up. So we can keep track and we have fixed the period to file this responsive pleading. As I said, we can now provide a timeline with respect to how a case is processed from the time it's initiated by a complaint up to the specific periods, depending on how good the judge is, because a case may be terminated, as I said earlier, at the very inception, assessing the complaint, or to a certain extent at the pretrial. Because an effective judge can say to the parties at the pretrial, I am at liberty to say that I will render judgment based on summary judgment or judgment on the pleadings. In some instances, pretrial may not be able to resolve all the issues and the case must proceed to trial. But still, the specific timeline now is possible under the amendments. Under the revised intellectual property rules, sections 1 to 4 of the original rule are now covered under one section only. When to render judgment will, as I said earlier, will vary at what stage the judgment is to be rendered, at what point in time in the proceedings, what is the warrants the rendition of judgment. It entirely depends, as I said, and I will reiterate, on the ability of the judge to skillfully, okay, handle the case such that there are periods, there are provisions in the rules that gives the judge the authority to render judgment. In civil cases, we have demurrer, we have summary judgment, and judgment on the pleading. So depending on the situation, like for example, the rule now says that there can be a clarification hearing, and after which the judge may render judgment. Now let's go to criminal procedure. Similar to civil procedure, the scope of the coverage on criminal cases was expanded to cover recent legislations, particularly amendments to the intellectual property law. But in criminal cases, we added a number of other legislations. For example, we have added, as part of criminal prosecution intellectual property cases, under this rule, violations concerning cyber squatting under Section 4A6I and Triple I of RA 10175, the Cybercrime Prevention Act of 2012. Again, the infringement of plant variety protection under RA 9168, the special law on counterfeit drugs in relation to Section 4, the Anti-Camcording Act, which involves intellectual property rights. For purposes of criminal cases, similar to civil actions, we have expanded courts, commercial courts, special commercial courts that may issue search warrants that may be enforced nationwide. Again, we added the urban courts, special commercial courts in the cities of Davao, Cagayan de Oro, Iloilo, and Cebu, as well as in Baguio. For purposes of disposing of goods seized pursuant to a search warrant, only the trial court where the action is filed with an authority to quash the search warrant or to suppress the evidence obtained or the release of seized goods. Again, to abbreviate proceedings, we have expanded the provisions on prohibited motions, which was taken up from the revised guidelines for continuous trial of criminal cases. These are based on experience, are dilatory motions. For example, motion for determination of probable cause. Because under the rule, it's the responsibility of the judge to determine probable cause for purposes of issuing a warrant of arrest. So why do we allow an accused to file a motion for determination of probable cause? The rule fixes the period within which the judge must issue a warrant of arrest, and therefore he must act on the information or complaint. Unmeritorious motion for investigation of the prosecutor recommending the filing of information once the information has been filed before the court, or if the motion is filed without prior leave of court. Again, based on experience, a reinvestigation causes delay, and jurisprudence is settled that once a case is filed in court, everything rests on the discretion of the judge. Crespo versus Mogul. Motion for bill of particulars that does conform to the specific provisions of the rules. Because sometimes the unique situation of a criminal case is that what? The allegations in the information under the rule is sufficient if alleges the following. Why the specific? Why do you have to have a bill of particulars? Unless the case is such of a complicated nature that the details are sought to be requested for the accused to be able to intelligently enter his plea. Again, we adopted the motion to suspend arraignment because the suspension of arraignment is one of the causes of delay even in ordinary criminal cases, which is no different in intellectual property criminal cases. We also adopted in criminal cases the specific grounds for motion for postponement. We know that postponement is one of the major causes of delays in the disposition of cases. Since we have restricted it, it's no longer possible for a party or a lawyer on the very day of the scheduled hearing to submit to the court a motion for postponement. Because unless the specific grounds upon are relied upon, the court should not grant a motion for postponement. Maraming dahilan nung araw para mag-postpone, di ba? On the very day, sasabihin ni attorney, masakit ang tiyan niya. Now, we only allow acts of God. If you can justify it in any of the other grounds enumerated in the rule, then we can allow postponement. But take note, we do not accept motion for postponement unless there's proof of payment of postponement fee under Rule 141. Okay. Again, to abbreviate the proceedings in criminal cases involving intellectual property cases, the rule now provides that the arraignment and the pretrial dates should be set simultaneously. Why? Experience again shows that, today the accused is arraigned. And then the judge will now set another date after a long while for purposes of conducting pretrial. Because arraignment will just take a few minutes, right? How do you plead after reading the information? That perfunctory ritual, right? And yet you set another date, perhaps 2 or 3 months after, to have the case set for pretrial. Now, when the case is set for arraignment, on the very date, the pretrial should commence. We adopted also in criminal cases the rule on demurrer to evidence, which is no different from demurrer to evidence in ordinary criminal case, because we believe that demurrer of evidence should be allowed in intellectual property cases also. As regards the rule on evidence, we adopted Section 2 Foreign Official Documents, which provides, if there is an existing treaty or convention to which the foreign country and the Philippines are both parties, the certificate or its equivalent shall be in the form prescribed by such certificate regarding such document and made by the appropriate Foreign Service Officer of the Philippines. The certificate or its equivalent is deemed prima facie evidence of the due execution and genuineness of the document involved. This is again to expedite the proceedings because the issue of authenticity and due execution of foreign documents and cases has reached the court for that issue alone. Evidence in patent cases. Second paragraph of Section 4 of Rule 17 was amended to allow the courts the creation of a committee of 3 experts. Each party shall within 30 days nominate an expert who then shall be appointed by the court. Thereafter, the court shall appoint a third expert from the list submitted from the experts of both sides. Technically in due time, my personal view is this will expedite cases because when it comes to appeal, similar to that of the SIAC, right? The factual findings of these experts should be final already, and an appeal is possible only perhaps on grounds enumerated similar to the SIAC rule, questioning the integrity of the composition of the panel of arbitrators. Because supposedly, the special commercial courts, okay, with the help of experts, will be able to assess the factual issues crucially, and therefore a review of factual issues can be eliminated down. So hopefully we can adapt that in due time. But this is the initial stage for that purpose. For purposes of evidence in trademark infringement and unfair competition, okay, Section 2 of Rule 18 specifically enumerates evidence of actual use in trademark infringement and unfair competition cases. We added last paragraph in Section 3 of Rule 18, provided that the mark may be well known regardless of whether the mark is registered in the Philippines. This is an innovation. This is precisely to ensure that foreign trademarks are are protected in the Philippines. Because if there are infringement, whether or not it is registered in the Philippines, the Philippines should extend protection to those trademarks. So we expect reciprocity in the end of the Philippine trademarks, whether registered abroad, they can be equally protected in other jurisdictions. As far as Section 5 of Rule 18, we added the last paragraph. Absolute certainty of confusion or even actual confusion is not required to accord protection to trademarks already registered with the IPO. As regards Rule 18, Section 9, we have now formally introduced in the rule of market survey because we believe it's high time we adopt market survey as evidence for purposes of trademark infringement and unfair competition cases. We believe that market surveys are reliable evidence because they are based on certain research and scientific approaches. Of course, we depend on the reliability of those who conducted the market surveys. Rule 19, Section 1, when copyright presumed to subsist. We added the last paragraph there too. Copyright shall be presumed to submit in the work or other subject matter to which the action relates if the defendant or accused does not put in issue the question of whether copyright subsists in the work or other subject matter. So the defendant or accused must directly put the question of copyright subsistence or ownership in issue. When their subsistence of copyright is established, the plaintiff shall be presumed to be the owner of the copyright if he or she or it claims to be owner thereof, and the defendant does not put in issue the question of his or ownership. Now, Rule 20 speaks of the disposal or destruction of infringing goods and related objects or devices. We have modified the rules as highlighted in the screen, but we added there's a second paragraph. There is destruction when the infringing goods are completely destroyed and are put beyond further use. There is disposal when the infringing goods are effectively prohibited from re-entry in the channels of commerce but may be reused for some other purposes. The motion for disposal or destruction shall be granted where the violation of intellectual property right of the owner right order has been established. Take note that the proceedings for purposes of destruction are summary in nature to expedite, especially if they're hazardous goods. Immediate destruction is necessary. We clarified what counterfeit trademark means in the amendments. Pirated copyright. The motion for disposal and or destruction shall be granted where the violation of the intellectual property right of the owner right holder is established. Now we specify in Section 3, hazardous classification of infringing goods. This is in relation to the rule on destruction. Now, the manner or method of disposal and or destruction of infringing goods. We specify the following methods of destruction that may be allowed by the court, depending on the nature and circumstances of the infringing goods, related objects or devices, crushing, shredding, and discarding at sanitary landfills. Minsan nakikita yata natin ginagamitan ng mga rollers, no? Or they put it in some destroying facility. Incineration. Okay ba to sa Clean Air Act? Encapsulation or other methods that do not pose any risk to the environment or public health and safety. Ayun. Provided that the opening or placing the goods in a in non-sanitary and open landfills shall not be allowed. Again, consistent with the environmental law. Okay. Another significant provision in Rule 20 on the disposal is with regard to the following methods: recycling, humanitarian donation. A number of imported what you call counterfeit items are seized in customs as soon as they arrive, right? If they're usable and safe for mankind, why should we automatically destroy? Although there are certain regulations that have to follow, other methods that do not pose any risk to the environment or public health and safety, provided that the manner of disposal must effectively prevent the re-entry of the infringing goods, related objects, or devices into the channels of commerce. This is a big responsibility for judges because part of the destruction process is to ensure that they are not channeled back to commerce. So the Section 5 must specify in the order, okay, the manner, method, and plan of disposal or destruction. It should be very clear how destruction should be made, and so that they can see to it that the destruction process was complied with. Section 5B Rule 20 provides that an authorized representative of the regulatory agency to witness and attest the taking of inventory photographs prior to the disposal or destruction. For example, counterfeit drugs, there should be a representative from FDA. MTRCB, perhaps for pirated movies or DVDs. The court officer authorized to supervise the destruction has submitted a report thereon within 5 calendar days from the date of disposal or destruction, similar to a return. In search and seizure, there must be a report to ensure that the method of destruction as set forth in the order are strictly complied with. So again, because we have allowed now the disposal by way of disposal humanitarian donation, we have set forth the requisites. A, the infringing goods will not cause harm to the donee. All infringing marks or features identifying the complaint plaintiff right holder as the source of the goods shall be removed to the most possible extent. So yung mga tags, alam naman natin yung lakos, ano ba yun, crocodile ba yan o lizard? When they are donated, they have to be removed. The government entities or charitable institutions to which the infringing goods are to be donated must be properly identified. Again, for the protection that these goods are not recycled in the commercial aspect. Thank you and good afternoon, everyone.
Thank you very much, Justice Hesmundo, for walking us through the significant changes to the 2020 IPR rules. It is now time to hear messages from the various stakeholders who will be affected by these changes. We are privileged to hear from Department of Trade and Industry Secretary Ramon M. Lopez, who will speak on behalf of the members of the business community who will be directly benefited by the implementation of these revised rules. Secretary Lopez sent us a pre-recorded message.
Chief Justice Diosdado Peralta, Associate Justice Alfredo Benjamin Cagiwa, Associate Justice Alexander Gesmundo, IPO Field Director General Roel Barban, Attorney Maria Trinidad Villarreal, President of the IPO Association of the Philippines, Chancellor Adolf Ascuna, the Philippine Judicial Academy. Ladies and gentlemen, magandang umaga po sa inyo lahat. With today's launch of the 2020 revised rules, we laud our good friend Director General Joel Marcos and the Intellectual Property Office of the Philippines, the Supreme Court, and the judiciary for safeguarding our country's intellectual property rights. The revised rules signal a rule of government advocacy in empowering our people to contribute to our country's national and socio-economic progress through the development of their intellectual properties. Thus, we are confident that these revised rules will aid our industries, inventors, artists, designers, creators, as well as our micro SMEs to maximize the benefits of their IP rights. What's more, the revised rules will foster a legal atmosphere that will spur creative activity and innovation, technology transfer, and foreign investment. Our country is already working towards creating a proper enabling environment that would help promote greater innovation and creativity. In the Global Innovation Index, GII 2020, the Philippines rose to 50th out of 131 countries from 54th in 2019. The first time that we have reached the top 50. Moreover, the GII recognizes the country as an innovation achiever for second year in a row. From 2014, we were just in the 100s, and now we are at 50th rank. We would also like to point out that the recently signed mega trade deal, the Regional Comprehensive Economic Partnership or RCEP agreement, has a chapter on IP that will push the Philippines to become an innovation hub for the region. With IP as a catalyst for our country's growth, we believe that the judiciary's activities on IP rights will enhance the government's efforts to accelerate our economic recovery. This is important given that many businesses, especially our micro SMEs, have been significantly affected by the economic challenges caused by the COVID-19 pandemic. The pandemic has already accelerated many technological trends and digital shifts in the country. As we gradually open our economy, new forms of businesses have started, with e-commerce taking a front row. In fact, online businesses registered leapfrog from 1,700 in March to around 86,000 by December, a clear indication of the adaptability of Filipinos in challenging times. As such, we need to encourage the conversion of more Filipino ideas into commercial assets so that local innovation projects can become sustainable and steady sources of livelihood. We need to make entrepreneurs and micro SMEs realize that their IP assets are the main source of their innovation for higher value adding, and in the end could make a huge difference in their company valuation. As they say, this is what separates the men from the boys. A company's innovation and growth in turn can potentially become massive generators of higher income jobs. To boost support for micro SMEs, the Department of Trade and Industry partnered with ITOPIL to assist our entrepreneurs in developing their IP strategies. Among these programs are the Wanna Make a Mark program, which waives trademark application fees for micro SMEs founded by a woman or a group with at least one woman as a member. There is also the Inventor Assistance Program, which provides free legal advice on patent applications and free basic seminars on patent search and drafting. Meanwhile, the IP Depot is an online marketplace where micro SMEs can market their IP protected products for free. We are likewise conducting free basic IP lessons for micro SMEs, which have been made available online in the wake of the pandemic. Lastly, DTI is working with IPO Field to protect our resilient Filipino entrepreneurs and their laban lang spirit by ensuring fair trade through the confiscation and destruction of pirated and counterfeit products. This will also bolster consumer confidence as our people favor local products and services that are more competitive and innovative. To close, DTI would like to thank Chief Justice Diosdado Peralta and the Supreme Court, the justices that are present here, for providing guidance and leadership on the intellectual property law. We are also grateful to the Philippine Judicial Academy, PhilJA, for working with the judges in expediting the disposition of IP cases. To the members of the subcommittee for the revision of IP rules, as well as the technical working group, we thank you for your hard work, invaluable insights, and expertise. We would also like to commend IPOPhil's effective IP enforcement team as they continue to work with the National Committee on IP Rights. And lastly, many thanks to the IP community and the stakeholders. DTI and IPOPhil look forward to a better and safer 2021 with all of you. We urge everyone here to continue assisting our innovators and entrepreneurs to register and protect their IP rights. As our micro SMEs grow and become successful through their innovations, they will generate more jobs and employment for our countrymen. This is the real goal of all our efforts so that our people can have a better and more comfortable quality of life, as promised by our President, Rodrigo Roa Duterte. Maraming salamat po at mabuhay tayong muli.
Thank you, Secretary Lopez. Next, may we call on Director General Roel S. Barba, who happens to be a relative of mine, to deliver a message on behalf of the Intellectual Property Office.
Thank you very much to the more handsome relative of mine. The Honorable Diosdado M. Peralta, Chief Justice of the Philippines, First Lady Justice Fernanda Lampas Peralta, the Honorable Justices of the Supreme Court, Honorable Amparo Cabatayetang, Presiding Justice of the Sandigan Bayan, Honorable Roman Del Rosario, Presiding Justice of the Court of Tax Appeals, Honorable Ramon M. Lopez, our boss, Secretary of the Department of Trade and Industry, Honorable Adolfo S. Ascuna, Chancellor of the Philippine Judicial Academy, our friend in the ease of doing business efforts in the government, ACA Jose Maidas Marquez, Judge Felix M. Reyes, President of Philippine Judges Association, Attorney Maria Trinidad Villarreal, President of the Intellectual Property Association of the Philippines, officials and colleagues in the IPOPhil, Philippine Judicial Academy, Supreme Court, Judiciary, and member agencies of the National Committee on Intellectual Property Rights, officers and members of the Integrated Bar of the Philippines, Philippine Bar Association, Intellectual Property Associations and Organization, IPAP, LESP, practitioners, partners, and stakeholders in the intellectual property system. Friends, ladies and gentlemen, good morning. I am extremely thankful and deeply relieved beyond words that I am appearing in this hallowed hall before the esteemed members of the highest court, not to orally argue a case, possibly every lawyer's dream or nightmare, depending on how one looks at it. But nevertheless, I am appearing here as an advocate for a robust, well-entrenched, well-balanced intellectual property system, fully cognizant of the social function of intellectual property and largely defined
by the imperatives of a developing country. I believe that we continue to successfully maintain this delicate balance with the adoption of the 2020 revised rules of procedure for intellectual property rights cases, another important milestone in the continuing evolution and development of the Philippine IP system. The Intellectual Property Office of the Philippines, or IPAFIL, is exceptionally grateful and lauds the Supreme Court and the judiciary for the approval of the 2020 revised rules of procedure for IP rights cases that took effect last November 16, 2020. This is another significant achievement for the court under the able leadership of the Honorable Chief Justice Peralta, with his remarkable knowledge, understanding, and appreciation of intellectual property. We thank you, Mr. Chief Justice, that the revised rules for IPR cases is among the priorities of your administration. It is highly auspicious that today's media launch of the 2020 revised IPR rules happens at the first day of Simbang Gabi, a uniquely Filipino tradition that embodies one of the best traits of Filipinos industry. Finding its origin in the early days of the Spanish colonial period, the Simbang Gabi is a practical compromise for farmers who began working before sunrise to avoid the scorching noonday heat out in the fields. Beginning around 1669, priests began to say Mass in the early mornings instead of the evening, which occurred in most of the Hispanic world. More than 3 centuries later, Simbang Gabi is a well-entrenched and eagerly anticipated cultural and religious practice, even amidst the health challenges. In the same vein, but on a different level, the revised rules is truly the sweat of the brow, to borrow the well-known phrase from copyright law, of the members of the subcommittee for the revision of rules of procedure for IPR cases and the technical working group. The revised rules is yet another example of the whole of nation approach in promoting and enhancing the intellectual property system, where the judiciary and executive branches, as well as the private sector, have worked in synergy, guided by the shared vision of enhancing judicial processes in adjudication of IP rights cases. This brings to the fore the importance of the 2020 revised rules in ensuring an effective and speedy adjudication of IP rights cases, an essential pillar in creating an environment that fosters innovation, promotes investments, and entrepreneurship. IPOFIL continuously works in enhancing our administrative and quasi-judicial processes, such as strengthening our alternative dispute mechanisms, adopting innovations like online mediation, constant streamlining of rules and procedures, among others, to complement judicial reforms. Enforcement of IP rights, especially in the digital world, where technology is being used and abused to commit counterfeiting, piracy, infringement, and other forms of IP rights violations, is more challenging than ever. The revised rules drafted with available inputs from the courts, law enforcement agencies, the IPOFIL, practitioners, IP stakeholders, and members of the Supreme Court has certainly taken into account the numerous logistics, legal, and operational challenges. This inclusive process ensures relevant and responsive rules in the effective and expeditious adjudication of IP rights cases. In the next 5 years, IPOFIL is committed to realize our 6-point agenda that we have coined as BRIGHT, or BRIGHT. B for building collaboration and partnerships. R for raising the ante for customer service, I for integrating, raising IP awareness, G for going back to basics, H highlighting human capital, and T transforming IPOFIL into a fully digitalized agency. We look forward to continuing this productive and excellent partnership and cooperation with the Supreme Court and the judiciary under Agenda 1, which is building collaboration and partnerships. IPOFIL expresses our commitment to continue our capacity building on substantive matters on intellectual property for the judiciary. While on this matter, we wish to make a very self-serving statement to our Chief Justice Peralta. We have not been naughty, we have been very nice. And hopefully our Santa CJ can grant our Christmas wish for the designation of a special division in the Court of Appeals to handle intellectual property cases. This could also be our New Year wish or our Valentine wish, Mr. CJ, whatever pleases the court. No pressure, Mr. Chief Justice, lest I be held in contempt. As we take the chairmanship of the ASEAN Working Group on Intellectual Property Cooperation, or AWG-IPC, by next year, we are bullish to show our leadership in the region, not just in the area of enforcement, but also in IP administration and management, education, and awareness. Fully recognizing that IP remains to be an effective business tool, IPOFIL is steadfast in its partnership with the DTI in promoting the use of intellectual property, particularly to MSMEs, inventors, artists, designers, creators, and all sectors contributing to national progress and socio-economic development. In closing, IPOFIL's advocacy in building respect for IP and enforcing the rights of IP owners and holders will not be successful if not for the support of our stakeholders and initiatives of then Chief Justice Lucas Bersamin, the strong and innovative leadership of Chief Justice Diosdado Peralta, and the members of the Supreme Court for approving the 2020 revised rules for intellectual property rights cases. Our deepest gratitude to the all valuable time and insights, expertise, hard work, and contribution of the members of the subcommittee for the revision of IP rules and the technical working group, and to my predecessor, former Director General Josephine Santiago, for commencing the review process. We also acknowledge our partners in the National Committee on IP Rights, or NCIPR, headed by my boss, Secretary Ramon Lopez, as well as IP associations and organizations, practitioners, and stakeholders for their inputs and collaboration. Their commitment and dedication over the years have made the Philippines' efforts on IP enforcement noteworthy in this part of the world. We are IPOFIL, and together we shall rise, shine, and beckon. Maraming salamat po at maligayang Pasko.
Maraming salamat po, Director General Barba. The next speaker is not a relative, but we went to the same law school in Diliman. Ladies and gentlemen, I am pleased to present Attorney Maria Trinidad P. Villarreal, President of the Intellectual Property Association of the Philippines, to deliver a message on behalf of the intellectual property rights practitioners.
In the interest of justice, I'm going to adopt the salutation given by the Honorable IPO Field Director General so as not to prolong the proceedings. I bring you the warmest of felicitations from the organization known as the Intellectual Property Association of the Philippines. Sorry, it's kind of high. I'm not that tall. Okay. An association composed of practitioners as well as IPR rights believers of 170 individual and firm members. We who have been practicing in IPR express our warmest felicitations and gratitude, utter gratitude to the Chief Justice of this Honorable Court because unlike when I was in law school and after law school, early years of practice, we are very heartened to find out and to realize that intellectual property practice or intellectual property rights protection has been given importance. I remember the days when I was still in the 1990s when I first practiced, and courts or judges would always ask, why even give importance to intellectual property rights considering that it is a personal offense and it only is for, they then argued, for members of first world countries or companies. That situation has since changed, especially because the Filipino has come to the fore in terms of creativity, innovation, and trying to do what is best for the economy and for the country. And therefore, we are very, very grateful that that kind of importance has been given. The rules of procedure, the revised rules of procedure, as very ably explained, very clearly explained by Justice Esmundo, are things that we really need in terms of expediting the practice and the protection of intellectual property rights. Practitioners such as myself and my colleagues in the Intellectual Property Association of the Philippines have had problems in trying to expedite the processing of cases. And we are thankful that measures are now being adopted and taken. Not that there were none before, but these are more expedient and, of course, right to the core, and hopefully will be able to prosecute and more cases in the coming years. And again, we express our gratitude. We also express our gratitude to the hardworking members of the committee for coming out with these rules that are very technically proficient and adapted to the times. But the one thing that I do understand that the number of judges are listening to us on Zoom. Apart from the rules of procedure, we also, the Intellectual Property Association of the Philippines would also like to express our help, perhaps, in the substantive aspects of intellectual property law. We believe that this goes hand in hand, not with just procedures. Yes, we may have the best procedures in place, but if the understanding of basic principles involving intellectual property are not there, then there is still a problem. And so we would like to offer our assistance. We have the Honorable Justice Ascuna here to the Philippine Judges Association in terms of our being able to provide certain lecturers, also for the members of the judiciary, not because we pretend to know everything, but perhaps because this is our field of practice, we perhaps can shed light so that we do away with previous practices that we have judges who perhaps may be confused with certain aspects of intellectual property law. And therefore, we kindly offer our assistance, the members of the Intellectual Property Association of the Philippines, to help in these lectures, to shed light, as I earlier said. I will end with a quote from the esteemed, my highly venerated icon, the just departed Justice of the U.S. Supreme Court, Ruth Bader Ginsburg. She said that we should fight for the things that we care about, but do it in a way that will lead others to join you. And that, I think, is what we should be doing. We should be working hand in hand, the judiciary, brand owners that we represent, the practitioners as well, towards developing as well as protecting and enforcing intellectual property rights. And we are heartened by the fact that the new rules aim to help this come to the fore. And as a child in a Catholic grade school, I would love to say it only takes a spark to get the fire burning. And this is a way by which we get the fire burning. Again, on behalf of the practitioners, who will be the ones to implement perhaps and find whether these laws are rather the rules of procedure are going to be in effect. We thank everyone. We thank everyone who gives importance to the intellectual property practice, as well as from the brand owners, the creators, the innovators, and the inventors. Maraming salamat po, at katulad po ng sinabi ng aking kaibigang IPOL Field Director General, maligayang Pasko at sana po ay patuloy tayong maging COVID-19 free sa madaling panahon. Bakuna man o hindi. Maraming pong salamat.
Thank you very much, Attorney Villarreal. And now to share with us his insights and experience as chairperson of the Committee on the Revision of the Rules of Court, or the Mother Committee, as well as chairperson of the Subcommittee on the Revision of the Rules of Procedure for IPR cases, it is with utmost pride that we present to everyone the Honorable Diosdado M. Peralta, Chief Justice of the Philippines.
Please be seated. Thank you. Honorable Justice Alex Desmondo, Honorable Justice Ramon Hernando. I saw Justice Javier a while ago. Honorable Adolfo Escona, Chancellor of the Philippine Judicial Academy, the presiding justices and associate justices of the Appellate Court, the Court of Appeals, Sandigan Bayan, and the Court of Tax Appeals, Court Administrator Semaidas P. Marquez, and officials to the Office of the Court Administrator, Justice Fernanda Lampas Peralta of the Court of Appeals, Attorney Roel Barba, Director General of the ISOPIL, judges of the Special Commercial Courts, Attorney Chidoro Pascua, Deputy Director General of the IPOPHIL, Attorney Nelson Loses, Deputy Director General of the IPOPHIL, Attorney Ann Edilion, Officer in charge of the IPOPHIL Enforcement Office, Attorney Nat Tanya Arevalo, Director of Bureau of Legal Affairs, Attorney Lolibet Medrano, Director of the Bureau of Patents, Attorney Maria Trinidad Villarreal, President, Intellectual Property Association of the Philippines, officers and members of the Integrated Bar of the Philippines, the Philippine Bar Association, the Philippine Association of Law Schools, and the National Committee on Intellectual Property Rights, members of the media, distinguished guests, ladies and gentlemen, and all those who are in virtual attendance, good morning. As Chief Justice and as Chairperson of the Subcommittee for the Revision of the Rules of Procedure for Intellectual Property Rights cases, I am greatly honored and privileged to present to you today the 2020 Revised Rules of Procedure for Intellectual Property Rights cases. These rules are the product of extensive consultations and thorough discussions between the judiciary and the stakeholders from various sectors, practitioners, the academe, and the IPO field. As our ultimate goal was to improve, facilitate, and expedite cases in response to the ever-changing landscape of intellectual property rights litigation in the country, all the members of the subcommittee unselfishly devoted their time and expertise on the matter. Given the challenges brought about by the COVID-19 pandemic, this meant that they all had to work doubly hard and go to the extra mile to ensure that the 2020 IPR rules come to fruition. Within days of my appointment as Chief Justice, I issued Memorandum Order number 51-2019, which reorganized the Subcommittee for the Revision of the Rules of Procedure for Intellectual Property Rights cases to include new members of the committee and of the Secretariat. The subcommittee was tasked, among others, to survey and compile the best practices employed by trial court judges, propose amendments to the IPR rules, and explore ways to expedite cases and decongest all the trial courts nationwide. In the first meeting of the subcommittee on September 18, 2019, the members drew up a work plan, identified the activities to be undertaken, discussed the expected outcome, and the appointed responsible focal persons. Also, a technical working group was tasked to look into the issues identified by the subcommittee and formulate a working draft for the proposed amendment to the rules. The TWG, which essentially had the same membership as the subcommittee, met at the Intellectual Property Office on November 5, 2019, and on February 19, 2020, and then at the Supreme Court on February 27, 2020, and on March 5, 2020. Even during the months when we are all forced to undergo quarantine protocols due to the current global health crisis, the members of the TWG worked tirelessly on the draft rules via online means. On June 26, 2020, the subcommittee conducted a hybrid virtual meeting with yours truly presiding and with Justice Gasmondo in attendance to discuss the working draft and improve on the proposed amendments to the rules. On July 14, 2020, the technical working group held a follow-up virtual meeting to finalize the remaining issues in the working draft. Thereafter, the working draft was finalized and submitted to the subcommittee for approval and eventually to the court and bank for final deliberations. The proposed rules were met with positive remarks and was subjected to only a few clarifications, suggestions, and insertions. Returned to the subcommittee, and it was returned to the subcommittee for fine-tuning. The subcommittee continued to meet via teleconferencing to exchange comments and corrections, as well as to discuss and incorporate the feedback of the justices of the Supreme Court. For the last time, on October 2, 2020, I called for a video conference with the subcommittee members to inquire in the provisions that were amended based on the inputs of the justices, since the proposed draft was already an item on the agenda on October 6, 2020 for the bank's approval. The 2020 IPR rules were approved by the court and bank on October 6, 2020 and took effect on November 16, 2020 following their publication. In revising the 2020 IPR rules, the salient features of the 2019 amendments to the 1997 revised rules of procedure and to the revised rules on evidence, which took effect on May 1, 2020, as well as the revised guidelines for continuous trial of criminal cases, which were in effect as early as September 1 of 2017, were incorporated and integrated therein. The 2020 IPR rules are designed to foster a legal atmosphere that ultimately spurs creative activity and innovation, technology transfer, and foreign investment. Upon my appointment as Chief Justice of the Philippines, I immediately came out with my 10-point program for the judiciary, which includes the continuous revision and issuance of rules of procedure so as to make the law more expansive and accessible to the needs of the court users, and the conduct by the Philippine Judicial Academy of more skills-based training for judges and court personnel. The approval of the 2020 IPR rules is the latest action taken by the court geared towards the objective of enhancing the effectivity and efficiency of judicial administration. It is a product of the judiciary's efforts to address the need to institutionalize procedural reforms that will simplify and expedite judicial proceedings. The PILJA, being the education arm of the Supreme Court, will no doubt include lectures on the 2020 IPR rules in its training programs and activities. Just last month, the Philippine Judicial Academy, in partnership with the IPOPHIL and the United Kingdom Intellectual Property Office, conducted the colloquium on intellectual property for the judiciary through blended learning methodology. The colloquium was designed to be a venue for the members of the bar to share their experience and best practices on the field of intellectual property for the effective disposition of such cases and was participated in by judges of special commercial courts nationwide. This orientation program of the Philippine Judicial Academy as regards the 2020 IPR rules proved to be monumental success in terms of participation and reception. It is my sincere hope that the inclusion of the 2020 IPR rules in the Philippine Judicial Academy's training programs would further promote and enhance judicial education in the country. May this be an essential tool for the courts and all concerned stakeholders to safeguard and thwart any infringement on intellectual property rights. Thank you and a pleasant day to all. Maligayang Pasko. Thank you. Thank you.
Maligayang Pasko po at maraming salamat. We are indeed honored to be in the presence of our hard-working Chief Justice. For the information of our participants, the Chief Justice himself envisioned this formal launch of the 2020 Revised Rules of Procedure for Intellectual Property Rights cases in order to make it known to all stakeholders.
To formally present to the court the publication of the 2020 Revised Rules of Procedure for Intellectual Property Rights cases prepared by the Philippine Judicial Academy, may we call on PhilJA Chancellor Honorable Adolfo S. Ascuna, a member of the Committee on the Revision of the Rules of Court or Mother Committee and retired Supreme Court Associate Justice. The Intellectual Property Office of the Philippines is our partner who provided support for the printing of the publication. An electronic copy of the publication will be uploaded to the Supreme Court website after this event.
Thank you very much, Chief Justice Peralta and Chancellor Ascuna. We also wish to express our appreciation once again to IPO Phil for their support for this publication.
To recall this occasion and for posterity, we would like to invite later for a photo opportunity with the Chief Justice, all persons physically present in the session hall today.
Before we end the ceremony, we wish to thank everyone who made the media launch possible, starting with the offices of the Supreme Court, the Office of the Chief Justice, the Office of the Court Administrator, the Public Information Office, the Program Management Office, the Management Information Systems Office, the Philippine Judicial Academy, and the offices that provided tremendous support to us. The Supreme Court Fiscal Management and Budget Office, the SC Medical and Dental Services, and the SC Office of Administrative Services.
This media launch was envisioned by no less than the Chief Justice himself. Thus, the personnel of these offices were inspired to hold this activity in the best way possible, even with logistical and technological challenges brought about by the COVID-19 pandemic.
Again, we would like to thank our partner, IPO Phil, for its continuous cooperation and support to the judicial reform initiatives of the judiciary.
To everyone who graced this event here at the SCN Bank Session Hall and virtually through live stream, thank you very much.
A pleasant day to all. Stay safe and take care.
We would like